A story can feel true when it arrives wearing the uniform of authority, a date, a precise time, a source inside the palace, a document described in rich detail, mahogany desks, blue drawing rooms, private seals, a clause hidden for years and then discovered at the exact moment it becomes most explosive. In late 2025, one such story began circulating again with fresh confidence, that King Charles had supposedly uncovered a secret clause in Queen Elizabeth II's will, one aimed directly at Prince Harry's inheritance, triggering an immediate, dramatic reshaping of royal family dynamics. It's cinematic. It's emotionally satisfying. It's also the kind of claim that collapses the moment you put it under real-world scrutiny. Because the British monarchy is many things: ancient, symbolic, cloaked in ritual, but it is not a private corporation where a CEO can quietly rewrite outcomes with a late-night signature. It is a constitutional institution embedded in law. And law leaves traces. So tonight we're doing the one thing viral stories hate. We're going to audit the claim, not to attack anyone, not to defend anyone, but to answer a simple, democratic question: if a hidden clause exists, how would we know? And if we can't know, what do we actually know about royal wills, secrecy, inheritance, and the legal machinery that sits behind the crown? The first hard fact is this: royal wills are not treated like ordinary wills in the United Kingdom. In Britain, wills are normally public documents after probate. But for almost a century, the wills of senior royals have been kept sealed by order of the High Court. In 2021, a judge ruled that Prince Philip's will should remain sealed for 90 years, citing the need to protect the dignity of the sovereign and close family members, while emphasizing that media organizations were not allowed to argue for publication. At the private hearing, that is not gossip. That is documented judicial practice, and it means something very important for any hidden clause. Narrative: the public is not reading Queen Elizabeth's will because it is not public. The idea that a secret inheritance clause emerged in a way that can be verified by ordinary reporting runs into a brick wall, the legal system itself. In fact, even in Philip's case, the judge noted he had not seen or been told of the contents of the will. The sealing order exists to prevent the contents from becoming a public spectacle. So, when a viral story describes a specific clause, amounts, conditions, days per year requirements, it's not breaking news. It's either pure fiction written to sound official, or speculation based on private briefings that cannot be independently verified. And that's not just a journalism problem. It's a state legitimacy problem, because when citizens can no longer distinguish between verified, constitutional reality and well-produced rumor, institutions lose the ability to stabilize public understanding. Now let's talk about what is verifiable in the inheritance ecosystem, because this is where truth is already dramatic enough. When Queen Elizabeth II died in September 2022, her private wealth and privately owned estates such as Sandringham and Balmoral passed to King Charles III. Multiple outlets have described this transfer and the basic structure. Private assets move through the line of succession, and there are long-established arrangements under which bequests from one sovereign to the next are exempt from inheritance tax to avoid erosion of royal wealth. This matters for a second reason. It explains why the public can't confirm what the Queen did or did not leave to individual family members through her will. Her will itself is sealed. Key private transfers can occur without a full public breakdown, and the legal architecture is designed to keep the monarchy's private finances partially opaque while the institution remains publicly accountable in other ways. So, what does that mean for Prince Harry? It means there are two separate realities. One, what is legally documented about royal wealth structures, including the fact that sovereign-to-sovereign transfers and certain royal estates are treated differently from ordinary assets. Two, what is publicly speculated about Harry's inheritance, an area where the information space is dominated by tabloids, unnamed sources, and narrative convenience rather than record. Even respected outlets often have to phrase Harry inheritance coverage carefully because hard numbers are not available in the same way they would be for an ordinary citizen's probate file. That vacuum creates a predictable outcome. a market for stories that claim certainty, and now we arrive at the core of the claim we're investigating. The idea that King Charles found a secret clause and that it reshapes everything. Here's the constitutional reality: even if a clause existed, the public would not automatically see it. Royal wills are sealed and handled through restricted procedures. And if any aspect of royal estate management required changes with constitutional implications, such as altering who holds authority to act on behalf of the monarch, that does not happen through a will clause. It happens through law and parliament. We've already seen the monarchy follow that pattern when it actually needed adjustment. In 2022, Parliament passed the Councillors of State Act 2022, expanding the list of Councillors of State by adding Princess Anne and Prince Edward after King Charles sent a message to Parliament requesting the change. This was done publicly, legally, and with a clear paper trail. That is the monarchy's real operating method when governance mechanics need to evolve, not secret midnight signatures, but statutory change. So why do these inheritance hidden clause stories spread anyway? Because they don't really sell inheritance. They sell something deeper. Closure. They offer the audience a storyline where conflict has a single cause, a document. Justice arrives through a twist, a clause. And decades of family tension become solvable through one revelation. Real institutions don't behave like that. Real families don't either. Prince Harry's relationship with the monarchy has been strained for years, and that strain has been documented in public statements, interviews, court cases, and the broader media environment, not in one magic document. Coverage of Harry's security litigation in 2025, for example, shows how ongoing disputes can remain unresolved even after repeated court judgments and public statements. This is the reality of modern monarchy. Its public stability depends on controlled messaging and careful constitutional process. But its private conflicts still play out under global scrutiny, and global scrutiny turns every gap into a story. So what can we responsibly conclude tonight with news context? Yes, there is no verifiable evidence in reputable reporting that King Charles discovered a hidden clause in Queen Elizabeth II's will on November 23, 2025, or that such a clause has been authenticated and publicly confirmed. There is strong, well-documented evidence that royal wills are sealed, and that secrecy around royal wills is enforced through the High Court, often for decades. There is strong, well-documented evidence about how royal private wealth and private estates transfer, including that Sandringham and Balmoral are privately owned and passed to Charles, and that sovereign-to-sovereign inheritance is treated specially in taxation arrangements. And there is a clear model for how the monarchy actually changes governance mechanics through parliament and statutes, as seen in the Councillors of State reform. That doesn't mean the public has no right to ask questions. It means we need to ask the right questions, because the real scandal isn't that a clause exists. The real scandal is how easily a well-produced rumor can hijack constitutional reality when the public doesn't have access to primary documents, and when the institution is structurally designed to keep those documents sealed. If you want to understand why a hidden clause in the Queen's will is such a powerful rumor, you have to understand one uncomfortable truth first. The British state is built to keep royal wills out of public reach. Not metaphorically, literally. There is a vault. There is a procedure. There is a judge who functions as custodian. There are sealed envelopes decades worth held under an exception that has existed for more than a century. And once you understand that architecture, you begin to see why stories about secret clauses spread so easily. Because the public has been trained to live without the documents that would settle the argument. The first battlefield is not the palace. It's the court. Under ordinary British law, a will is usually a public document after probate. Royal wills are different. In September 2021, the president of the High Court's Family Division, Sir Andrew McFarlane, ruled that the will of Prince Philip should remain sealed for 90 years from the grant of probate. The court described this special practice as necessary to protect the dignity of the sovereign and close family members. That ruling matters for today's rumor economy. Because it includes two details that destroy the viral fantasy of a will clause suddenly emerging. First, the court hearing itself was held in private. Media organizations were barred from attending and from making arguments. McFarlane accepted the position that only the Attorney General represents the public interest in these hearings. In other words, the public does not get an advocate in the room when secrecy is granted. Second, McFarlane explicitly noted he had not seen or been told the contents of Philip's will. The secrecy is procedural, not content-based disclosure, and then there is the detail that feels like it was written for conspiracy theorists, but is actually just administrative reality. The judge is custodian of a safe containing more than 30 sealed royal wills, including those of senior royals. This is not to say something sinister is automatically happening. It is to say the system is designed to keep the documents inaccessible, and that design inevitably breeds suspicion because secrecy creates an information vacuum, and a vacuum creates a market ###, hidden clause discovered. vs. How sealed wills actually work. The rumor you've been presented with relies on a cinematic premise. A hidden clause is discovered in a private briefing, producing a dramatic new inheritance framework for Prince Harry, but if royal wills are sealed, the public cannot verify clauses, and even the court system is structured to treat the contents as a protected private sphere. The 2021 ruling also laid out that after 90 years, there would be an initial and private review process involving the monarch's private solicitor, the keeper of the royal archives, the Attorney General, and others, before any decision on unsealing is made. That is a slow, controlled, closed-loop process, not a sudden morning revelation that would be credibly reported as fact. So, here is the investigative conclusion that matters for your audience. If someone claims to know exact figures, conditions, day count requirements, or detailed trusteeship terms allegedly written into Queen Elizabeth II's will, that information is not verifiable through normal public channels. Because the will itself is not public. In a responsible documentary, you can still cover the impact of these rumors, but you must label them for what they are. Unverified narrative content built to exploit the sealing system. ###. The second battlefield is money and the monarchy's unique financial structure. The inheritance rumor also spreads because people are trying to solve a puzzle that is real. Royal wealth is a mix of public, private, and institutional assets that do not behave like ordinary estates. When Queen Elizabeth II died, much of what Charles inherited did not pass in the way a normal family's assets would. The UK government has long-standing guidance that exempts certain transfers from inheritance tax, especially transfers from monarch to monarch, partly to preserve the monarchy's financial independence and avoid gradual erosion of sovereign-held assets. That means the public sees private estates, royal collections, duchies, and hears conflicting descriptions of what is personal wealth versus institutional wealth. This ambiguity becomes fertile ground for stories about secret clauses and hidden financial control. And again, this doesn't prove wrongdoing. It proves a structural fact. **** opacity plus exceptional legal treatment. Intense public interest *** will always generate myth. ###. What can the king legally influence, and what can't he? Here is where the rumor gets its most dangerous power. It implies that Charles can reshape the family forever through one private discovery and unilateral decision. In reality, Britain separates family drama from constitutional authority more than viral content admits. King Charles can set the tone of relationships, approve or deny certain royal arrangements, influence informal family dynamics, and operate within existing legal structures, but he cannot rewrite succession in secret. And he cannot simply replace statutory mechanisms with a private document. When Charles needed an operational fix to ensure public business could continue smoothly, especially given that some next in line royals were not active working members, he didn't do it by private decree. He went through Parliament. The *** Councillors of State Act, 2022 ***. is the cleanest proof of how the monarchy actually modernizes. It explicitly added Princess Anne and Prince Edward as additional counselors of state people to whom royal functions can be delegated through an act of parliament. The text even includes a royal message stating the king would be most content if parliament increased the number of eligible counselors under the Regency Acts and the underlying authority is not invented. It's in the Regency Act 1937, Section 6, which sets out the power to delegate royal functions by letters patent under the Great Seal in cases of illness not amounting to full incapacity or absence from the UK, to prevent delay in public business while also restricting certain powers such as dissolving Parliament except on express instructions. This is the real constitutional landscape boring. Legalistic and durable. So what does it mean for the Harry Inheritance Clause story? It means this. The story is emotionally plausible because the family rift is real and public. The story is structurally plausible because royal wills are sealed and secrecy exists. But the story is not verifiable, and therefore cannot be responsibly presented as breaking news fact. A professional documentary approach is to say, the rumor reveals what people want to believe about power, control, and money, but the legal system that governs royal wills makes that rumor exceptionally difficult to confirm. And the monarchy's modern track record suggests major institutional shifts happen through parliament and statutory change, not secret midnight paperwork.